welcome to this session. This could be a little nightmarish in relation to technology because we have two speakers, one in the States, Colin from Modria, and one who's from the Netherlands but is in the United Kingdom. So there will be some glitches, I would think, but it should be a very interesting session because these are two guys right at the cutting edge of their field, which broadly is online dispute resolution. Now, first speaking is Colin Rule from Modria. Colin has a long history in the movement. He's the founder and chief operating officer of Modria, which is powering, linked with, advisor, and also is involved in the MyLaw package. Colin, we're going to start with you. I think we're going to begin without you on visual. But your first slide is up and in front of the audience. Welcome.
Great. Excellent. Thank you so much for having me, everybody. I wish I could be there with you in person, but I think in terms of walking the walk, it's appropriate that we're doing a technology-based presentation with Maurits and I remote today. So Maurits and I discussed how we want to structure things. I'm just going to talk a little bit about ODR at a meta level, and then he's going to get into some of the specifics about the work that we've done, particularly with HiiL. I know Sherry is presenting later in the afternoon to show off some of the MyLaw BC platforms, so I think we're going to get a lot of really good information about ODR today. So hopefully you're looking at my first slide here that says, what is ODR? Online dispute resolution really has only existed for about the past 15, 16 years. It was first conceived of in the mid-1990s, but it didn't really take root until, say, 1999, 2000. And fundamentally, ODR is the use of information and communications technology to help parties prevent or resolve their disputes. Now, a lot of people think that information and communications technology is synonymous with the Internet. And the Internet is a very powerful technology in that regard. But other technologies are also under the umbrella of ODR. Teleconferences is a good example. And there's a lot of in-person technologies as well that don't necessarily leverage the Internet. But the beauty of ODR is there's new technologies being invented all the time, and the frontier of the Internet is expanding, so the relevance of ODR is similarly expanding. So I was the director of online dispute resolution at eBay and PayPal from 2003 to 2011, before I started Modria. And I'd written a book called Online Dispute Resolution for Business, and eBay said, wow, we really could use your help. So they brought me out, and we built something called the Resolution Center. So eBay at that time had about 250 million users, and when I left, eBay was doing about 60 million disputes per year. And the Resolution Center is a piece of software that every user of eBay all around the world has access to, where if they have any kind of problem, they can just come in and click a button, report the problem, and then track the problem all the way through to resolution. And we learned a lot from building the Resolution Center and scaling it around the world. But one of the things that we found is because there were so many disputes at eBay, 60 million a year, we only had 25,000 employees. We really had to leverage software to resolve these disputes efficiently at scale. And eventually we got to the point where 90% of those disputes reported were resolved in software only, meaning no human intervention was required to engage those disputes other than the two parties, the buyer and the seller. And we also got to the point where 50% of the disputes reported through the Resolution Center will resolve amicably. The other point that I'd make is this is an extrajudicial process. It's not a pre-dispute binding arbitration process. So while every user of eBay has the legal right to appeal the outcome in court, 99.999% of these users never did, because they felt that the Resolution Center process that was provided to them was transparent, it was fair, it was easily accessible, and they were comfortable thinking about that as sort of final redress for their problems. So at eBay, a lot of the people I worked with, they really saw this as a customer support flow. But I really felt, and again, my background is in public policy, I felt like we were building more of a civil justice process for a country. If you counted up those 250 million users as citizens, eBay would have been the 5th largest country in the world at that time. So, we had to build a civil justice system from scratch. And the reason why is because the offline face-to-face legal system simply did not work for these cases. These cases are too high volume, they're low value, they cross borders, so jurisdiction is very complicated. figuring out how to enforce these outcomes is also complicated because these users only sort of exist in cyberspace. The other thing we found is that our customers at eBay demanded these fast one-click resolutions. We discovered that parties were so frustrated with a resolution that took longer than 10 days, they wished that they had never reported the problem in the first place. So the time frame on the internet is very condensed. And those expectations are being brought to other areas of people's lives. Obviously, everyone's using Gmail, everyone's using Facebook. So users are demanding these rapid resolutions. So the beauty of online dispute resolution is it kind of works the way the internet works. You can build these online redress paths and embed them directly into where the disputes arise. And you can automate a lot of dispute software. So as computer processors become more powerful, and the technology tools available become much more robust, that means we can leverage all of that for online dispute resolution. So the good news is over the last 16 years, there's been a lot of analysis of ODR, and there's a great tailwind behind ODR right now. UNCITRAL has just closed its Working Group 3 on online dispute resolution. It has 66 member delegations from all over the world participating in this working group, and they issued a paper that calls for access to robust online dispute resolution for global consumers. The UK Civil Justice Council just did a big report on online dispute resolution, and that effort was led by Richard Susskind, and it calls for the creation of something called Her Majesty's Online Court, which would be an online-only redress process available to civil disputes worth less than £25,000 in value. So there's a lot of activity going on in the UK. That's one of the reasons why Maurits is over there right now. But also the European Union passed a regulation that requires every merchant within EU member countries to advise their consumers of the availability of online dispute resolution. And the EU launched its own intake form for taking in those cases. In Canada, obviously, I'm sure you guys know a lot. You're going to hear from Sherry later, as I mentioned. There's a lot going on in British Columbia. We've been working with Consumer Protection British Columbia. We've been working with the Property Appeals Assessment Board in British Columbia. But the Ministry of Justice is also launching their civil tribunal, which is an online civil court as well. So I believe that these types of systems really represent a huge opportunity for us to expand access to justice. And these tools are relevant in a wide variety of different areas. Now, obviously, Modria is focused on e-commerce because that's a need that's not being met by the existing judicial infrastructure around the world. So we focus on payment providers, on online marketplaces, both for services and for tangible items, and we focus on merchants. But we also are the #1 processor of online property tax assessment appeals in the United States. We handle the property tax assessment appeals in New Orleans, Louisiana, and Nashville, Tennessee, Atlanta, Georgia, Gainesville, Florida, Durham, North Carolina, a bunch of other places, in addition to the work that we're doing in British Columbia. So public disputes is another huge area for us. We also run the largest case volumes in the American Arbitration Association, the New York no-fault process, which is hundreds of thousands of insurance cases a year. But we're also working in other areas, product liability. We're doing a lot of consumer protection. I mentioned Consumer Protection British Columbia, and courts. I mean, we're having lots of conversations about traffic court cases, small claims court cases, restorative justice cases, and then obviously family, which is the collaboration that we've done with HiiL. So pretty much all of these different, what we see is ODR was created to meet the need in e-commerce, but as the tools get better and more robust, we're seeing them extend into other areas. And what Modria has built is really a toolbox. It lets you build appropriate dispute resolution flows. We say in dispute resolution, we want to fit the forum to the fuss. So what we've done is we've built Modria stands for Modular Online Dispute Resolution Implementation Assistance. And we have all these components you see at the bottom, diagnosis, negotiation, mediation. I'll talk through those in a second. But essentially, we're extending the toolbox to build online multi-door courthouses that can resolve a wide variety of different kinds of problems. So it's easy to file a case. There's an enterprise interface for administering these and assigning neutrals and maintaining panels of human neutrals. We have a policy center that enables rule-based resolutions. That's where the automation comes from. And we've worked really hard to abide by all of Silicon Valley's cutting-edge design standards. So the entire platform is API-enabled. We have a publicly documented API. We've met all the security certifications. We live in the cloud, so we are in Amazon Web Services. Unfortunately, Amazon Web Services does not have a server cluster in Canada, So because we're doing so much work for public entities in Canada, we had to create our own server cluster on the IBM cloud. But fundamentally, the platform is structured, and this is for the technical people in the audience. I won't spend too much time on this, but it is a multi-tenant software as a service platform. So that means, in essence, customers sign up for a subscription to the platform, and then we become partners. It's not like we deliver software and give it to the client and they have to run it. We manage the entire system, and we have certain service level agreements and that we abide by. But we can configure new instances. We can push button create new instances and then configure them online so that every single instance is client specific, and we can support thousands of instances, supporting hundreds of millions potentially cases. Also, we support external identity providers and web services, so anything that's out there on the internet and abides by basic web service protocols can plug into our system. I mentioned we've met the security certifications, and we meet all industry standards for document management, encryption, and e-signature. So you can see some of the components there on the right-hand side, some of which we've deployed in the RecVisor platform. So I want to hand it over to Maurits, but let me just talk briefly about these different components and give you a short example, because I think it's helpful to think about sort of what we call the escalation staircase. So every dispute has a life, from when the disputants themselves realize they have an issue all the way through to resolution. So I've talked a lot about the DNME model, which is diagnosis, negotiation, mediation, and evaluation. So diagnosis is the first stage, and that's where someone says, wow, I think I have an issue. Maybe they think, gosh, maybe I want to get a divorce, or, you know, maybe I should do something about this workplace issue that I'm experiencing. So a lot of what we do is build these online wizards to help set expectations, guide users through the thought process, and I think you'll see some of this with MyLawBC. They do an excellent job in the diagnosis phase. But we've built similar diagnosis wizards. This is one we built for the Ohio Board of Tax Appeals. Is it worth appealing? Do I have a case? What are the steps? How long is it going to take? These are the kinds of questions that parties usually call up the Ohio BTA and ask, and we can put this into an online wizard and in some cases deliver an automated resolution based on the information submitted. So the next phase is negotiation. And this is where parties communicate directly with each other without a third-party neutral. It's software-assisted to try and reach a mutually agreed-upon outcome. And we can support synchronous communication like what we're doing now, voice-based or video conferencing-based, but also asynchronous text-based communication, and enable the parties to make offers and then accept and reject them, upload relevant documentation, and even jointly draft negotiation agreements that they can accept or reject. So this is an example of a property tax platform where we enable the local assessor in Nashville to negotiate with the taxpayer to try and come upon a mutually agreed upon outcome. Now, mediation obviously is just assisted negotiation, but you bring in the role of the third-party mediator. So our platform can support caucusing, private conversations between the mediator and the parties, as well as joint conversations. It can track issues. It handles panel management, and you can pick mediators. I think you'll see some of how that works. But you can also look at a library of relevant solutions or use tools like online calculators to determine things like spousal support. So you'll see more of this with RecVisor and BCLSS later in the day. And then finally is obviously arbitration or evaluation. Obviously, arbitration implies a certain level of legal enforceability, and there are a lot of evaluative mechanisms that we've created that are not legally enforceable, but they do provide that closure in 100% of cases. So as I mentioned, we run the New York no-fault process for the American Arbitration Association. So automatic notifications, case timelines, scheduling, calendar management, enabling decisions to be automatically drafted so that once an arbitrator is ready to make their decision, they can go in and click a few options and it automatically drafts the document. And then also integrated billing and account management if there are any fees that need to be charged to the parties for the process. So fundamentally, the takeaways that I'd like for you to have from my presentation is online dispute resolution is a big step forward in terms of access to justice. A core concept in dispute resolution is this idea of the multi-door courthouse. And Frank Sander first presented this at the Pound Conference in the 70s. And he said, instead of when parties walk in the door, we shouldn't just usher them in front of the judge. We should have a table there and say, what kind of dispute do you have? Well, I have a family dispute. Okay, you should go through door number 1. What kind of dispute do you have? Well, I have a landlord dispute. Okay, you should go through door number 6. What we want to do with our toolbox is build an online multi-door courthouse that doesn't just have 10 doors or 100 doors, but maybe tens of thousands of doors, or maybe an infinite number of doors. Maybe we can custom build appropriate justice pathways for each individual dispute based on the information we collect from the parties. And that enables us to fit the forum to the bus and best meet the needs in a scalable way for disputes. We also believe that consumers and citizens are going to demand these types of redress. This is the way that people balance their stock portfolio or sign their kids up for summer camp, is through online channels on their mobile phones. We need to be able to meet that expectation by delivering these systems. I personally believe that ODR is the best opportunity we have to expand global access to justice. And as we say in the ODR field, ADR is alternative dispute resolution. Well, it's an alternative to what? It's an alternative to the court. But in ODR, there's no A. It's not an alternative. For many types of disputes, particularly low dollar value disputes with confused jurisdiction, ODR may be really the only option for justice. So this is my contact information here. I would welcome anyone to reach out if you'd like an in-depth demo or if you have any further questions. So with that, why don't I hand it back to Maurits?
Okay, Colin. Well, I'm assuming you're going to stay online while we have Maurits, and then we can have questions and discussion with the two of you at the end.
Yes, I'll be here for some of it, but maybe not for all of it. So, but I will be on for at least the next 30 minutes or so.
Okay. Okay. So, Maurits, you need to welcome.
Hello.
Hi. You need to share your screen. Which means you have to knock Colin off the...
All right, I am no longer presenting.
Yep, okay, Colin, you're off. Maurits, this is your chance.
Yeah, I'm trying to find the right button for knocking Colin off and present myself.
Well, we've got a screen which says, feel free to start presenting.
To press on the monitor icon.
Okay, here's the instruction. You've got to press on the monitor icon.
The monitor icon. How about this one?
We have loaded.
So now it's loading my presentation again. I have uploaded it before, but maybe you can take a few questions from to Colin first before I upload it. There it is.
Maurits, you're uploaded, so I would be tempted to roll on while we've got you.
Okay.
Okay.
Great to be here. Great to meet very small pictures of friends from BC and Roger a bit bigger and here in Colin. Sorry for not being able to meet in person, and I hope my presentation is in line with where you are during the conference. What we built on top of Colin's wonderful system is really an interface that is meant to be not robotized law, not an online system automating justice, but building legal procedures that really care for people, give them time to think about the most difficult moments in their lives and good solutions for that. Let me take you back to a little bit of a personal history. My grandparents, they divorced in 1936, a very long time ago. And it was a kind of a special kind of separation because after some time they each remarried the parts of another couple. So I've never known anything else than that I had 4 grandparents from father's side. And from these 4 different couples, because the remarried couples got children also, I had half uncles, real aunts, nothing at all aunts, seven siblings of my father in total in strange constellations, and they all got children themselves. And my family's history is a little bit an experiment of the consequences of divorce, because many of these siblings also divorced. Four of the seven divorced, and the grandchildren also had the impact of divorce. Some of them did what is expected. They failed at school. I even had a nephew who ended up in jail and had a lot of drug problems that would not be expected normally in my type of family. So what this illustrates is the enormous impact of divorce on people's lives, and if you get it the other way around, the enormous impact the justice system can have on people if we get it right. It's 60 years of happiness you can create, not being depressed as likely as you would be from a bad divorce. There's violence that comes out from divorce. There's an enormous value that can be added. If you look at how the legal system performs now on divorce problems, you get very low scores. We do access to justice surveys in many countries, and divorce procedures have the lowest score we find compared to, for instance, employment procedures or consumer procedures or neighbor disputes on our scale for access to justice, which measures several components of justice, procedural justice and distributive justice, but also costs and stress and what people experience at that side of the equation. So it's really very urgent that we do something about better separation procedures. And the only way to realize that is probably that we make use of the possibilities of technology. What you see here is that there's also in Canada a lot of data that show that it's a similar situation as in Holland. And the way forward should be technology. Imagine an average divorce problem. It's a complete reorganization of your life that has to happen, and there's more than 25 issues on average that you have to take care of. If you would like to do that through the normal one-to-one services of the legal system, you will certainly get in trouble. How on earth is it ever possible that we support people on a one-to-one basis through 25 issues that require a lot of thinking and a lot of attention and a lot of coordination and negotiation? It is impossible to deliver good service on divorce problems without using the possibilities of online. We are working on this system which is built on the Modria platform, and this is the key slide that I will present, which shows how the system works. This slide is basically what the couple works on when they are really resolving the issues. In the top circles, you see the 5 most important areas for that have to be resolved, from communication to housing, and of course a lot of issues around children. And then in the left, to the left, you see the sub-issues, and as I said, they add up to 25 issues. And for each issue, the parties work on agreements. And not only the parties work on agreements, which you find in the center. The whole system is organized around getting out great and high quality agreements. If a mediator logs in, and you see bottom at the bottom you see a button for that, and I will not show the entire process how a mediator is involved. But when a mediator logs in, he also helps to the parties to formulate an agreement about this issue. And the same is true for an adjudicator. This system doesn't work with a system where if the parties cannot agree, they have to go to a court with a lot of documents and claims and defenses from both sides. No, we have reframed the intervention of an adjudicator as filling in the gaps of an agreement. And this is a method that is based on how most judges in family courts currently actually work. Most modern and problem-solving family court judges will, at a certain stage of the court hearing, push aside the legal documents and ask the parties and the lawyers what the problem is and what the possible solutions are. And that's exactly what we want to facilitate with this platform. Basically, it's entirely oriented towards building agreements. At the right side, you see that it's possible to give people targeted legal information. For each issue, the rules of the game, whether it's child support or how you split up assets, you can give the core rules at the right-hand side, so that people can see what the rules of the game are. The solutions you see in the center are based on choices the parties make during the intake process, and depending on whether they agree on the first ideas of where they want to go, they will get a text here that is already targeted towards a certain solution that is a good practice, or the screen is more open and leaves them more options to agree on a specific solution. There's all kinds of views that the parties can have of their progress. There's an agreement view where you see all the agreements made, and of course the output of the system is an agreement where that people can file at courts. Let me tell you a little bit about how we built this system and what the constellation is in which we work, and where we are looking for more partners to make this new way of doing family justice come true in more countries. We have had a good relationship with the Dutch government from the beginning. They supported us with a little subsidy, and we worked with the Dutch Legal Aid Board, and it's good to see how people using the platform also use the government's certification of the system as a source of reliance. And also, of course, that creates a lot of responsibility, because if you are government certified, many people look at the system and want to avoid risks and increase the quality. But it's something that the users of the platform greatly appreciate. These are a number of the features that we have built on top of the platform. At the structured real-time negotiation is basically an adaptation of the familiar Google Doc, where you can work in simultaneously. Both parties can see what they contributed, and they can work really real time together on a text. But of course, they can also use it in their own time, like any Google Doc. We thought very much about the terms of reference for each of the phases. We structured the intake process in such a way that we really build the attitude of the parties, gradually inform them about what they will encounter, and make them ready for a problem-solving mediation. So we ask intake questions about interest, which is a typical process, of course, also used in mediation. But we also ask them to identify first ideas for solutions without seeing what the other party has submitted. So there is no reaction to proposals of somebody else. No, you make up your mind first yourself, and then the computer compares the solutions that you have found. And the great result of that is that from the beginning, people see that they agree on many points, and that there's only so much work to do to agree on the other points. Mediation and arbitration, which you could substitute for adjudication, because we very much hope that we can integrate the system with family courts at some time, are phases that are not obligatory, but we have an obligatory review by a lawyer. There's two reasons for that. The first and most important one is that the users ask for it. In an early version of the platform, we left it to themselves to build agreements, but users started asking for a review by a neutral lawyer who could protect them against unintended or intended unfairness, and also about against legal mistakes. We are building a phase now which makes it possible for the users to adjust their agreement, which we think is a very important part of the divorce process. Getting it right the first time, reorganizing your life in an agreement once and for all, that's almost impossible. People change their living environment, they meet new partners, children grow up, there's new needs, and so the adjustment of the agreement is almost as important as getting the initial agreement right. We are working on a number of additional features now, which enable both the end users and the professionals working on the platform to smoothen their operations. And that's very important. This platform is not only intended at making the life of the end users better, but it's also very much enabling legal professionals to do their work in a more effective and efficient way. The whole story about robotized law is not something we buy into for divorce problems. If you look at it in terms of revenue created through the platform, still 80 or 90% of the money that goes through the platform goes to individual legal assistance. But it's positioned in a better way so that people can be more effective in helping people out in these difficult moments. The platform very much is based on co-creation. We worked through different stages to build the platform, and using modern innovation techniques to have a user-centered business journey, because that's what it's all about. We believe that flexibility at this stage of the development is very important, and that's why working with a configurable platform such as the Modria platform, is so important. We are finding out how this works, and we can't rely on case law by high courts to develop this step by step over decades. We need to be fast in improving the system. We have developed rechtwijzer platforms also for landlord tenants and for debt columns, and the application that is running for LSS in British Columbia will be shown later today, and you see there that we also have helped to build guided pathways for other columns. Basically, we want to lead in a number of respects. We want to lead in making procedure design evidence-based, using best practices from all over the world and research results about what is the best way to resolve divorce problems. We want to work together with broad coalitions because we believe that procedures should be owned by the entire supply chain. It shouldn't be owned just by one organization, and it shouldn't be owned by legislators making procedures and leaving it to the practice to supply it. We should have a joint ownership of it. And of course, we very much believe in putting the user and user experience central in everything we do. I think, Roger, I have to stop here because my presentation seems to have but there I am again. Sorry for this interruption.
That's okay. Are you going on, Maurits? Can you move your slides?
Yeah, I can move the slides. You see the slides, our consortium?
Yeah.
This is just a slide about the Canadian market. When we look at this, investing in online solutions for relational disputes would make a lot of sense. If we look at the results that we now have in Holland, we have now a real base of people who had already done that before through rechtwijzer. Basically, the experiences are a lot better than the current legal system, but we are still working on improving the user experience and especially calibrating what the online system does and what is done by reviewers and lawyers still needs a lot of improvement. But it's very interesting to see how lawyers are motivated to improve the operation of the system. If we look at the costs, I must say that working with the Legal Aid Board has pushed the prices that we ask on the platform to the low end. We are thinking about this, and perhaps it is better to spend a little bit more on divorce loans. We think that the value that can be added by a good divorce agreement allows spending a bit more money on it. But that's something that you could think about together. The user appreciation, I talked about that. We have a lot of stories also on our website showing how people experience the working with the platform. We are, as you perhaps know, attracting also some international attention with this platform, and we very much hope that we will be one of the anchors of a bigger market of organizations that develop innovative procedures, because we think that that is the the way access to justice can be increased. We can keep thinking about giving people more access to individual lawyers and judges, but the future is in redesigning the procedures in such a way that they help people out of the crisis of their life. If you look at social impact, the impact a good divorce procedure can have on families, it's really amazing what you can achieve by working on a good divorce procedure. Of course, it's difficult to estimate what the effects will be, but these are the kind of social impact indicators we are discussing with investors who are interested in participating in this venture. If you look at the access to justice impact, platforms like this allow governments to save money, but it doesn't necessarily mean that lawyers and judges and courts will earn less money. We really believe not in cost cutting, but we believe in adding more value and asking citizens to pay more for this type of sophisticated legal services because they add more value to their lives. And if you think of that in terms of divorce, think about how people now spend money on a document at the moment that they separate, and think about a process where they are building better agreements, which facilitated by a platform like this over a number of years and spreading the expenses for having these services over a number of months. This is basically how we work when we work with a new client organization. I will skip that slide quickly and give it back to Roger.
I missed the last part of what you said, Maurits. Were you coming to an end there?
Yeah, I was giving it back to you, Roger.
Okay.
And you missed that one. I hope this is the only one you missed.
Maurits, I'm going to ask the audience if they have any questions for you. And if people stand on a designated spot, you should see them as they ask. I'm going to ask...
Colin is still online as well, if somebody has a question.
Oh, Colin, hi. But perhaps let me just ask a first question, because I know the two of you have collaborated in the second version of the latest version of the Rechtwijzer, and I think with My Law BC, and possibly with the Relate product in England and Wales. And I wondered if one or both of you could just talk about the relationship between the two of you. I mean, how does it work with HiiL and Modria? Who brings what to the table, and is it basically a static pick and mix arrangement from Modria, and then the Rechtwijzer team puts on the front end together with the local partner? Or how does that actually work?
Yeah, why don't I start, and then Maurits, you can elaborate. We at Modria are very, very proud of our partnership with HiiL, and we are brothers in the objectives of trying to put together systems that can expand access to justice and really represent, the cutting edge in terms of how ODR systems can be deployed. Modria provides essentially the back-end infrastructure. So we manage the servers, we handle the back-end code, we handle the uptime, we handle the security certifications. We're providing that sort of robust, configurable back-end. And then as you described, HiiL has actually built this beautiful front end and is constantly tweaking and adjusting the front end in cooperation with its customers and partners. So I think I sort of think of us as sort of the back-end infrastructure provider, and I think of HiiL as the customizer building sort of the user layer on top of that back end. So, Maurits, I hope you see it the same way, but why don't you lay it out as well?
Yeah, well, what I see is that Modria has built an incredible platform where every thinkable action in a legal procedure can be programmed. That's the beauty of the vision of Modria. If you think about the divorce application, you have to realize that there's hundreds of screens that users can go to or refer to. There's an enormous amount of notifications that have to go to people. There's a clear distinction has to be made between different phases. In different phases, you have payment moments. In different phases, you have different access rights. That can all be done on the Modria platform. So for any thinkable legal problem in the world, you can configure in the Modria backend a good procedure. Now, what we add to it is finding out the exact language and interaction flow for between these screens. So the whole relational interaction has been designed by us, and getting the right issues on the screen, getting the right type of solutions in the screen. If you click buttons when you choose it, that whole area is done by us, and that's also a front-end design that is user-friendly. What we also provide is integration with the legal services and court community. A lot of the work we have to do when we launch this type of systems together is integrating it with current systems. So you have to understand how a legal system works, what the interests are, how the business models work, who is paid by whom, what sensitivities there are with the bar, how to handle them, and that's the type of knowledge we have as well.
Are there any other questions that people would like to raise? Slight problem with me being moderator is I have a whole series, I have a stack of questions just waiting for you. No one in the audience is trying to catch my eye, although I would be interested in hearing somebody from BC who's worked with you talking about how the lessons you took from the collaboration, and I'm going to ask my question and then encourage one of you from BC to come in perhaps in relation to anything that arose in relation to working together, even if it's to say how good it was to work with outside partners. The question that I want to ask is, Colin, you put up a slide showing your work in relation to, illustrating your work in relation to courts, the appeals in the state of Ohio, and that, as I understand it, would be a state-based, court-based system, where you're producing a system for the court. And I'm interested in the difference between that, and that would be the model for the CRT in BC, and it's the model we coming to us in Wales. The difference between that and the Rechtwijzer, which was initially developed by the Dutch Legal Aid Board, and which could exist in my law in the court. And I'm wondering if that's a distinct, and it seems to me a very important distinction in terms of what you can put into the program in terms of advice and information, how independent you can be. And I wondered if that was a distinction which you two, as people involved in it, would also agree was important.
Sure. That's a great question. The Ohio Board of Tax Appeals, actually, it's an administrative law process in the state of Ohio. It's actually not under the judiciary. It's under the executive. So the Ohio BCA, we call it administrative law processes often reside within the executive, but it is a quasi-court. It operates as a court. It's lawyers that are filing the cases, and decisions are rendered under the authority of the BTA that have precedent in the same way that a court has precedent. Now, I think one of the things that Mourits pointed out, and I want to underscore this, is the beauty of the HiiL process and what they've gone through with RecFizer and with Relate and with MyLaw BC is that they convene large groups of stakeholders that cross many areas of society. That could be attorneys, it could be family law attorneys, it could also be family mediators, it could be social workers, it could be psychologists, it's also government employees that work for agencies, legal aid authorities that are concerned with the process. So I think a lot of the diagnosis processes, and I think you'll see some of this with MyLaw BC, are built in conjunction with those agencies. And the diagnosis process that I showed you from the Ohio BTA, that was put together by the Ohio BTA. Modria did not put any of the content into that system. We, again, just provided the platform. But I do think you put your finger on a very important concern, which is obviously the organizations that set these systems up, if they kind of have a dog in the fight, there may be an opportunity for them to, shade the content in one direction or the other to sort of set expectations for the parties in a certain way. And I think that it's incumbent upon us when we put these systems together to convene a wide variety of stakeholders, make sure we get broad-based support and input on how the platform should operate, and also provide transparency around how these diagnosis mechanisms and what content is available on the site. I think those problems are navigable, but I think you've named a very important design concern, and one of the reasons why we love working with HiiL is because they're so good at convening all of these groups and getting them on the same page. I attended one of the meetings at BCLSS that HiiL helped to convene, and there were so many very interesting people from all parts of society coming together to talk about how should this work and what information should be available. And it was sort of broad-based buy-in on exactly what flows would be concentrated on and what content would be provided. So I think that that's an important design concern. I'd be interested to hear what Mourits has to say about that as well.
Yeah, I think that is a very interesting topic. What we see is that our platform creates a lot of discussion about what type of information people should have before they consent or before they agree to certain solutions. And that's indeed very interesting because it now becomes transparent what type of information they get. In the old world, everybody goes to his own lawyer, and yeah, we all, in a way, trust the lawyer to inform people, to give them the right amount of information, to give them choices, etc., etc. But of course, we all know that if we talk about 25 issues, it's almost impossible for any lawyer to guarantee complete overall informed consent. So there's a very interesting discussion now going on with the lawyers in the Netherlands, what informed consent actually means. And one of the ways we have approached it is by looking at a number of issues that should be certain that people are aware of. Certain issues about their rights, certain issues about, for instance, not agreeing that one party should pay the debts without informing them that the cooperation of the creditor is needed, things like that. But the basic issue is that online systems allow us to make much more transparent what actually happens in the legal system, and it allows us to increase quality in that way.
Well, and may raise ethical issues which are not transparent or which are built into the system. But that's another whole debate. And I've enticed Sherry McLennan up here, who is either going to ask you a question or is going to make a comment about working with the two of you in relation to MyLaw BC. So, Sherry.
Hi, Sherry.
Hi, Mourits. Hi, Colin. It really was a pleasure and is an ongoing pleasure working with HiiL and Modria. One of the reasons we chose to work with them because they clearly had a shared commitment to access to justice values. To access to justice values was really important to us, and that's one of the reasons why we worked with them. And we learned so much in the process, beginning with HiiL's guidance on convening the different parties together, because it was more than just bringing different parties together to discuss what the pathways would look like, but it was actually the beginning of our knowledge engineering process. And it was a real shift for us as a traditional public legal education provider, where we work with lawyers who would tell us what people need to know, and then our editors would put that in plain English. No. We had self-represented litigants with family matters. We had people who had visited the Access Pro Bono Wills Clinic. We had people that were struggling with these issues on their own because they couldn't afford a lawyer, work with us and be engaged in the process from the start. And that helped us achieve our goal or strive towards our goal. One of the earlier speakers commented, I can't remember who it was, but it's about giving people the information they want and in the way they want it, instead of the way the lawyers think they should have it. And that makes it engaging, relevant, and accessible.
Okay, I think that's a statement rather than a question. And I'm minded, are you coming with a question? We have one question coming up here, standing on the X.
I just wanted to explore the idea, and I talked with you a little bit, Sherry, about this earlier, of some kind of a national legal aid, IT, innovation kind of forum, because BC has done a fantastic job developing this application that's going to help many people, but it's the same application really across the country. And so when you look at, for instance, things that cross across, whether it's criminal law, which is consistent across the country, or immigration refugee law, it seems that there's opportunities on a national level to pool resources, to pool knowledge, and to develop one platform that could be called Legal Aid Canada, rather than Legal Aid Ontario, Legal Aid BC, and so on and so forth. So I'm just wondering what your sense of that is, and for others, obviously, on the panel.
And I'm going to intervene as the moderator to park that for the afternoon, because at the moment we've got Maurits from the Netherlands and Colin from the States. And I just want to ask you, I want to link up from you about, that was a question about national link-ups, which is something for Canada to follow. But I wondered if the two of you had any observations to make in terms of the international links that you've been making. And you're both out there selling your product. How's it going in Australia for you, for example?
Yeah, if I could just weigh in, and this unfortunately would be my last answer because I'm going to need to jump off in a minute. I'm not going to be there this afternoon, so I do want to weigh in and sort of give a thumbs up to that idea of building a national platform. I think there are a lot of efficiencies to be achieved by joining purposes, and you guys in the room are the ones to make that call. I will say that there is sustained global interest in how ODR can improve access to justice. And Maurits, both of us did a trip to Australia recently, and it was amazing to see how much excitement there was around ODR. The enthusiasm there is sustained. We've just signed a partnership in New Zealand. There's a conference happening on ODR in China next week, and the Chinese government is giving a strong lean forward. And I'm going to Singapore the week after because they're very interested in how ODR can assist their access to justice challenges. My office is in India. My co-founder, Chitu, is there, and we're working with the Online Consumer Mediation Center and the National Law Center on how we can use technology to improve access to justice there as well. So I had that slide that was sort of talking about tailwinds behind ODR. I think a lot of that is happening in the e-commerce space, but now I think we're really seeing sustained global interest. I mean, I just had a call this morning with Brazil. And the government there has passed a law that requires mediation in advance of civil cases, and they encourage people to use online dispute resolution. So I think that this is not going anywhere. I personally believe that this trend is only going to accelerate, and the more people look at it, the more they realize it's a good idea. And I think maybe the Modria HiiL partnership, we're one of the first platforms. Whether or not it's our technology that gets used, I think that this is the way of the future. So with that, I'm going to hand it back to Maurits, and unfortunately, I'm going to need to log off.
Thank you very much for your contribution.
Thanks.
Maurits, have you got a short word, a couple of sentences to add to that?
Yeah, I think that working across jurisdictions makes a lot of sense. And let me first point out that most jurisdictions are small in the world. So you have to really look at your budgets that you can afford for developing platforms like this. If you want to develop it for the most common disputes and probably a few recurring criminal law problems, you're talking maybe about 20, 25 different modules you want to build in the next decade or so. Doing that on your own in a state, a province, or a small country like the Netherlands, that's probably not sustainable. And the next thing is that we have learned when we build a platform in the Netherlands for divorce and also for landlord-tenant, and when you bring it to another country, you can translate a lot. It's about 95% of the content of the platform that can be reused. It may sound strange, but when you look at the rules that people really need, justice systems are much more similar than you might think. Things like formulas for child support or the formulas for dividing property, they have a similar structure in different countries. So there's a lot you can reuse and jointly develop and improve.
Okay, that's really interesting. I'm going to just bring in our last questioner from here, who's going to stand on the X, and you're only talking to Maurits. Colin is gone.
Oh, all right. Well, excuse me, Craig Covell from Legal Aid in Saskatchewan. I have worked with Sherry and Legal Aid in British Columbia in the past, and one of the concerns that we always have is the literacy levels and the literacy problems that people have. And I'm just wondering whether you have, in terms of taking into account how you develop systems, a special, I'm not sure what I'm trying to ask here, a special functionality by bringing in human intervention on the literacy issues, because you can't, I suppose, build a system that is so rudimentary that it will cover everybody. And so if either maybe Sherry has a quick comment on that, or it's how you take that into account.
I can start. When we were developing the content for MyLaw BC, we developed it at a grade 6 to grade 8 literacy level for the for users. And one of the things that we particularly appreciate about the platform is we're developing the content. It actually limits you as to how much you can say in terms of blocks of text. And I know that was based on did as to how much people were willing to read. And so Maurits, I'll turn it over to you.
Maurits, this is your last word, and it's a pretty key question, really. How do you deal with levels of illiteracy?
It's spot on. I think there's two things to say, basically. I think we have to work on visualization. The future will be much more pictures and much less text. The second thing is that systems like this, and that counts for every legal procedure, it's built, if it's well done, for the average citizen with average levels of understanding and literacy. There's always a group that needs special assistance. We think that a system like this can help people a lot who serve the people with disabilities in that respect. If a social worker or a legal aid lawyer helps the most difficult clients to go through these things and can use this system to log all the information, we think that that could be a great way to use a platform like this as well. I hope that answers your question.
It does. There are no further questions. We are really grateful for you prevailing with the technology and your voice coming out anonymously without a picture, but you did very well in communicating what was going on, and thank you very much.
Thank you for allowing me in, and have a good afternoon, and I look forward to seeing you all in the future.
Cheers. Take care.